It's not often that you are given a grand conspectus and overview, the overture to this today's symphony. I like to imagine a metaphor. We are all into metaphors, from bullies to drones. And then we are treated to a very structured, in some way, going from the big macro patterning of geopolitical to the macro patterning of issues concerning arbitration. A quick unpacking of phrases by Patricia. But Benjamin, of course, taking up the baton, has also given us a more deeper view. And then followed by Dr. Oveis, all right, who helpfully gave concrete case studies dealing with issues which all lawyers grapple with. The intersection between public and private is indeed exemplified in this morning's discourse. Now we have two panelists in front of us, and we have dying questions from the floor. I don't want to start the thing unless there's quiet and lacuna in the discussion. Then we will start throwing some salvos at them. But maybe, all right, from the floor, the rules will be very quick. Put up your hand. Someone will give you a microphone. One sentence introduction of yourself. Make a comment. Ask one question, all right? Try not to have multiple questions. If there's a break, we will ask you, come back to you again. Shall we do that now? And then we move the discourse. All right, we have Faris, all right? Faris, stand up a bit. I think it's good. We like to look at your handsome face. Can you hear? No, working. It's all right. Yep.
Thank you. Well, I have many questions, but I'll try and limit it to one. We've heard of the traditional force majeure contractual definition, including warfare, amongst other things. We've also heard this morning that sanctions can be considered equivalent to economic warfare. With that in mind, is it perhaps time to reconsider the traditional definition of force majeure that is contained in contractual clauses to include economic sanctions?
Someone would remark? Ben?
As I was listening to Oveis speak, I was thinking an act of Obama has become an act of God now. And, I'm not sure that's a healthy development. But I do agree that a sanction can be an act of war. We've seen, I mean, the traditional, this historical lesson perspective we got this morning was, I think, very helpful. That laying a siege and cutting off a country can lead to disastrous consequences and lead a country to feel its very existence is threatened, which I think was what happened with Japan leading up to World War II. And as Oveis led off his speech, if I am unable to perform the contract because I'm going to be sanctioned, I'm going to be criminally prosecuted, or I'm simply unable to get access to credit, if that's not force majeure, what is? I think it is time to include that in that definition. Sanctioned countries should not be innocent commercial sanctioned parties should not be left without a remedy when these issues arise. And that's my.
And even in the elements that I elaborated, there is a hope that some sanctions, I mean, some international sanctions on some specific companies goes under the force majeure. I mean, as long as you can prove that it was irresistible and unpredictable, so why not? I mean, you can do that. But what I understand is mostly the jurisdictions who are under international sanctions are reluctant to construe it broadly. And because if they construe it broadly, most of the contractors working with these states can just go under the shadow of being force majeure and just step back from their obligations and do not complete their obligation in that countries. And you know, well, Iran, Libya, and other countries that are under the sanctions, they are developing countries that require contractors from outside, and the contractors are working in these countries. So if we just construe it broadly, we are making it easy for these contractors just to say goodbye and accept no obligation and pay no damages for this matter.
Well, just as a quick interface, and then you know, the whole issue of contractual allocation of risks, right? We are into this area when we talk about force majeure and frustration. We're coming from a common law tradition, as you articulated, Dr. Oveis, that there is a strong restraint or inhibition by courts and even arbitrators, if the choice of law is English law, that unless the contract specifically, your two illustrations are excellent. The insurer that said that, you know, we have exit. The other one, hey, you didn't quite provide for that, all right? Therefore, contracting parties should be given, you know, their own allocation of risk negotiation. But given a situation where Ben just talked about the act of Obama, act of God, and, you know, it's now becoming such a strong platform that we are in a situation where many contracting parties should be aware that there are sanctions. What is your comment on that? I mean, how do contracting parties allocate the risks in the wake of sovereign states taking unilateral or multilateral action? How is your response to that? Would you like to respond, and Benjamin, on that? Just have a quick comment, and then we take questions from.
Well, I've seen many contracts that in the contract it is mentioned that if, well, specifically after 2006, with the possibility of further sanctions exist, they mention in the contract that any further sanctions or developing of the current sanctions goes under the risk of one side. So actually parties prefer to, right now, when the situation is risky and there is always a fear that the new sanction is enacted or the previous sanctions are developed, so they prefer to allocate the risk, to say, okay, if something came up, if something comes up, it goes under the risk of the employer, which is the state, for example, or it goes under the risk of the contractor. And we have a number of cases. I mean, I have seen a number of contracts that, for example, they allocated that the risk goes under the risk of the contractor. Well, of course, in such situation, the contractor bids higher for the price of the contract because it also accepts the risk of the contract and the risk of all other matters that might come up.
And the pricing mechanisms and all that. Ben?
I agree. I mean, it's a matter of allocation of risk when that is foreseeable, and I think it will affect the price of the contract. And I think now it's hard to argue that it's not foreseeable.
Precisely.
Yeah.
Pat, you want to say something quick, and then I'll take the question from the gentleman up there. Right.
Actually following up with this very discussion, if we use the example of the Russian sanctions, then we have the situation, as you mentioned, Benjamin, that the burden of proof is on the party trying to escape that, even if they do have the right to some review. And then we look at the situation of trying to prove whether or not it was predictable, was it foreseeable, and how far does the contracting party have to go to explore the developing political situation, and how far back and how deep to determine whether or not that was a foreseeable action to meet that burden of proof, and also how far they can go, even if there are potentials to get exemptions, to go through the process of applying for the exemption, to prepare that application and the period of time for that to be processed, which may be a very, very unlikely positive outcome. You still have to go through all of that if you want to retain your contractual or legal right to claim frustration and possibility of force majeure, particularly in light of when you have a burden of proof shift in the sanctioning instrument. How do you deal with that?
It's all done after the fact, of course, and it becomes very counter-speculative, what they should have and could have and possibly might have done when you're sitting in as an arbitrator in a case, because these issues arise because these things were not done. And so it's very difficult because you find yourself in a position of wanting to do justice, and you understand the position of both parties. As you mentioned in yours, I agree with both sides, right? And they eventually settled that amicably. But I don't envy an arbitrator who has to make that decision. A party faced with their counterparty not performing and they're left holding the bag, or another party that wants to perform but can't because they don't want to go to jail. I mean, and this is why I think this is so pernicious, because it's like shooting a buckshot, to hit a hummingbird. Sorry, I'm from Texas, so it's. And it interferes with some of the, it has a lot of unintended consequences. It interferes with a lot of private commercial relationships that should not be the target of these kinds of measures. So.
Well, before I call a gentleman, just a quick interface. Just listening to this, the interface between public, looking at the development in political science and jurisprudence, the international arena of Pak Sun Savanda, right, the sanctity of contract, and then the national sovereign saying, I have the doctrine of necessity, I can do what I want, and I want to declare war by means of economic sanctions and trade, and then it impacts the private treaties and private contracting parties. This interface is extremely controversial, and thereby birthing issues that are now emerging in this morning's discourse. I dare say that, so this is an advertisement. Stay on with us throughout the day. We hope to unpack this a bit more and the nuances, and we will really be enriched with the discourse. I'm just throwing a new dimension to this again. Yes, this gentleman first, and then the next one over the left side. And we'd like to have questions from the ladies. Many ladies are here, and we will hear your voice too, other than Pat's, all right?
Thanks, Philip. My name is Ernest.
Sorry, repeat the name for everybody.
Ernest.
Ernest. All right.
Yeah, all right. I would like to talk about sanction that's very close to home. In 1991, a Malaysian company entered into a contract with a Libyan company, manufacturer of oilfield chemical instruments. And the Malaysian company, subcontracted it to another Malaysian company, and they manufactured it almost complete. And what we found out later was that the other Malaysian company, the manufacturer, was actually a wholly owned British company. Now, the wholly owned British company, the DTI, Department of Trade and Industry, informed them that they cannot go ahead with the manufacturer or handing over the goods to the Malaysian company for export to Libya. It's all an LC arrangement, back-to-back LC arrangement. So we had to go to court and took an injunction and asked for specific performance. Now, the ground they gave was that these instruments could be used for oilfield, so-called oilfield chemicals could be used for chemical and biological warfare. Our Malaysian court said, look, you prove that to us, we will not allow this to go. They couldn't bring any proof. The parties renegotiated, and the contract was supposed to go. Now, that's the second part now. Since they couldn't stop it, they went to the United Nations, they got embargo. Now, the contract says direct shipment to Benghazi, Libya. This was 1992. So what happened was the company that was manufacturing it, they shipped it to Singapore. The sanctions bit in Singapore on the goods, fine. So our company said, well, go ahead, we can't do anything about it. Hey, but I want to get payment on the LC. Now, they went and took an injunction on the LC. And we went back to court. Our Malaysian court decided, look, this is a purely commercial transaction. This is an LC. It says no transshipment, you transshipped it, you bear the risk. The goods remain with you, you bear the risk. Now, the reason I bring this up is because this was way back in 1991. After I heard the gentleman, then it kind of jogged my memory. Yes. Now, how would that kind of situation be if it was an arbitral tribunal deciding on this issue? What will the arbitrator do? Of course, our courts decide one way, and of course, I feel the courts were right. But if you're an arbitrator, how would you handle this? some
We
views.
will ask the very senior arbitrator in this panel called Benjamin Hughes, all right?
Yes, Mr. Benjamin.
Who
I was
wears-
looking at him.
Who wears both common law and civil law hats.
That's right.
Well, I would carefully review all the submissions of the parties, hear all the evidence, and make the appropriate decision.
And then we say amen to that, right? Because he said amen to Tony Kevins, right? But thank you, Ernest, for bringing it home to Malaysia. And when you just said that, it resonated with a very important common law case. I think Lonho and Shell BP, all right, where the House of Lords, then known as the Supreme Court, lifted the corporate veil. I mean, this whole area birthed an intersection of not just public international law, but private law orderings, contract law, corporate law, shipping law, banking law. Oh my God, none of us are equal to this task now, right? But that's why we are lawyers and we charge good fees. So thank you for introducing that case. Maybe we can talk about it as we move around and then lunch and all that, and then, but it's so long ago. But thank you for that very wise response, all right? Next question over there. And then after that, Dr. Raslov. I think there's a question. Someone put a hand up there somewhere. Yes. Introduce us quickly and make a comment or a question.
Hello, good morning, Mr. Speaker and panelists. My name is Michael. I just want to bounce off with, I mean, this is another scenario, but not a real scenario, but a fictitious one. So let's say if there's an Australian company enters into a bargain with an Indonesian company, and unforeseeable events happen. Probably, let's say if the Australian government suddenly imposed sanctions on Indonesia because of the Bali 9 execution, but let's say. In those circumstances, when the Australian company can't perform their bargain because of these sanctions, they use that as an excuse of not performing their contractual obligation, and let's say this matter was brought to an arbitral tribunal, KRCA, and the arbitral tribunal fined in favor of the Indonesian company, probably because the force majeure clause was not widely being drafted. Would there be any difficulties then for the Indonesian company when it comes to Australia to enforce the award? Because obviously if you come to the Australian court, the Australian company would say it's against public policy. Would there be a difficulty then in terms of enforcement? I take it even further. Let's say if the Indonesian company knows there's this difficulty, tries to enforce it in New Zealand instead, because they know that the Australian company has some assets in New Zealand. Would then there be a problem then, because the New Zealand courts would say that, look, international committee, part of our public policy as well, would that also jeopardize its enforcement as well?
Well,
Thank you.
Excellent example. I think unpacks what Benjamin was trying to share about, he didn't use the word, executory contract, about to be performed, executed. Is it discharged by performance in terms of, frustration, supervening impossibility or force majeure of frustration? And then you hinted, Benjamin, and in your talk about enforceability. So again, the wise man called Benjamin Hughes will respond to this very interesting case study.
I won't give you as cheeky an answer this time. No, I mean, it's again, they wanted to perform the contract, but they're not able to perform the contract because of the sanctions. Now they've got an award against them, and you would probably have an issue with enforcement in Australia, because this is Australian law that's preventing the payment to the Indonesian company in the first place. This points to one of the advantages of international arbitration, right? You didn't specify what the governing law of this contract was, but if you have an award that has been rendered under the in an arbitration agreement seated in a New York Convention jurisdiction, it can be enforced elsewhere. New Zealand is probably not your best option if you can go somewhere else, but for Australia, I'm just kidding. But I mean, I do think you would have the same issue with enforcement that you would have with performance in the first place.
Oveis?
I guess the question also goes with all enforcement issues that touch the public policy matter in different countries. So you will have the same problem in any other country that, well, the country recognize that the matter is touching its public policy. So I think that, as Ben mentioned, that you can also enforce it in all 152 other countries that are 54 countries that are under the convention, New York Convention. New York Convention and you can enforce it. But the problem you are having in Australia is not specifically regarding the sanction issues. Any other matter can go under the public policy issue of any country.
Was seated in Australia. Of course, it could be set aside in Australia on the public policy grounds, and then that provides a ground by which any other New York Convention jurisdiction may, but is not required to, refuse enforcement.
Fascinating. Dr. Yaroslav, yeah.
Yaroslav Krivoy, University of West London, and CS Arbitration Forum. My question actually relates to the point which we just discussed, and it's an existential question. Do we really need a conference on sanctions, or can we just treat sanctions as mandatory law? Now, what makes sanctions so different that we need to treat them as a part of a separate conference? And a related question, what are limits, contractual limits, in predicting sanctions? So how about having a standard clause for all contracts stipulating what is the effect of administrative actions, adverse administrative actions, be they domestic or international, and perhaps we can also define what force majeure is. So what makes sanctions so different? Thank you.
Well, commensurate to Russian, he first started off with saying it's an existential question, so we're all now going to be philosophers for the next 5 minutes. I wonder, anyone of the panelists want to respond? Wise man again?
Why do we need a conference on sanctions? Because it's a wonderful...
Why are we here?
Yeah, exactly. This is a sort of a Buddhist kind of conference. Because I was promised there would be a very good lunch. Short answer. No. I think it's a very interesting issue, especially for a jurisdiction like Kuala Lumpur and an institution like KRCA, because it is going to create opportunities to serve parties who may no longer be able to have access to justice in their traditional venues, such as the UK. And you know, I think it's a commendable thing for them to discuss. But I do think sanctions are somewhat different than mandatory law. Of course, if you've chosen the law of a sanctioning jurisdiction, it's mandatory law. It's no different really than anything else. But there are many cases where, and maybe you're using mandatory law in this broad sense as well, but a law applicable to a party which is not contemplated in the contract at all, like capacity, for example, is it different than capacity in that sense? Yeah, I think the nuance and the sort of parameters of it are different. And then, you know, as was mentioned in the talk this morning, people who want to do, entities that need to do business in the United States that have really no, they're not subject to U.S. law in the general sense, but will pay the fine that almost $9 billion, right? Because it's an existential issue for them. They can't exist without compliance. So I think the reach is potentially much broader, and in some ways the implications are a little bit more disturbing. Mandatory law applies when you've chosen a seat, you've chosen an applicable law, and you're a citizen of some jurisdiction, and this goes beyond that, I think.
Any comments? No. Well, thank you for the question. You know, I think we'll unpack it and we'll throw the question back at your panel. All right. All right. Pat, I think you could help us with some comment. Come, what do I sit down here?
Now, I have a follow-up question, and that is that in discussing with a colleague, a friend of mine who's chief counsel for a big Swedish exporting company, Ericsson, that's quite active, and there's a lot of markets that they may be active in, such as sanctions involving Burma, Iran, a number of countries. They have a staff of lawyers, more than one, who are trade sanction lawyers, specialized in this area. And that's what they do. That's hired just to do that. And so they're specialized, more than one, just giving advice. But the example you gave us, Oveis, of the sheet metal producer, an ordinary commercial party, that doesn't have access to an in-house lawyer probably, let alone one specialized in the ever-changing landscape of trade sanctions. And how does that affect regular commercial parties trying to do business on a global basis? How is it going to affect the future of trade?
And rising the cost of doing business, internal governance, compliance officers, these are issues that are going to be set the whole discourse on sanctions. And I think we are beginning to go under the skin and looking at some of these things. And this is really moving the way we want to move it, this discussion. Next comment from the floor. I think there's a lot of energy.
Can I add a
Oveis.
comment, please?
Please.
Yes. Well, fortunately, in recent years in Iran, a number of lawyers have specialized their practice on the sanctions matters because many corporations and many companies in Iran are dealing with this matter and they have disputes over that. So I would say we have also, some lawyers specifically working on this matter, and sometimes you see some contracts that are having a very, very strange force majeure clause so that it covers the international sanctions as well. In a recent contract that I noticed, it was mentioned at the end of the force majeure clause, it said, okay, any event might be force majeure, and at the end of the force majeure clause, it was mentioned that a written certification of the Chamber of Commerce of each country will suffice for proving force majeure. So in case the Iranian party wanted to prove that it was a force majeure, I couldn't fulfill my application. All it needed was to go to Chamber of Commerce of the country and just show them documents. Well, for example, in our case, I provided all documents, I provided all guarantees for bank, but the bank was not able to open the letter of credit. So what can I do? What can I do, in this case? And the Chamber of Commerce could provide it with a written notice that, yes, this guy did all his best to fulfill his obligations, but it was impossible in this situation. I'm saying we are coming across with different contracts with different force majeure clauses in order to provide the clients with more protection.
Yes.
My name is Dr. Zain Shara. I'm from Qatar International Court. I just wanted to make quick comments from my experience. In international contracts where the parties come from different countries, I find often, and I've seen many cases, where they said, okay, let's agree on a neutral law, the governing law, and they put English law. And believe it or not, both parties, they didn't know what's the English laws governing many issues. So this is where the parties has to be very careful about the governing laws and how we deal with different issues like force majeures and frustrations of contract. It's fascinating because I found it all the time. Where I come now, I work in Qatar now, and I found many local companies when they're contracting with overseas companies, they say, let's agree on a neutral law. We don't want the laws of Qatar. We don't want the law. So let's agree on the English law. And I asked them, do you know anything about English law? And they said, no. So this is one of the issues that I just wanted to...
So the era of Pax Britannica law is on the wane, but maybe a comment from a person with combining both civil law and common law ideas. Benjamin again, of course, yeah.
Well, I think that there's a certain comfort level with UK law because people think that it's a very well-developed body of law, and people have used it without incident. But it's another opportunity, I think, for Malaysian lawyers or Singaporean lawyers, because if you want the common law to which you've become accustomed in dealing with these shipping contracts or whatever the other issues are, construction contracts, you can have that without the sanctions by choosing Malaysian law or Singaporean law, and choosing your seat in Malaysia. And choosing the KLRCA. There are other options. I'm not trying to, they're providing lunch today, so. So yeah, I think it's a matter of education. Just coming back to this point that Patricia raised about these specialized lawyers and sanctions and how there's a developing practice in Iran. Is anyone else terrified by that? Do you know why we cannot change the ridiculously complex tax code in the United States? Because thousands of educated lawyers make a lot of money preparing taxes. And there are government bureaucracies built around sanctions now. And it means that it's becoming institutional, and we are going to have a very hard time getting rid of this. And I think what that means for the relationship, as you alluded to, between Russia and the West is not good news. But what it means for places like Malaysia in Asia, a lot of opportunities.
Maybe a quick comment about civil law. How does civil law, because we hear a bit of that in the discourse, how does civil law look at the issue of force majeure? I mean, some of us are not from civil law. Maybe you give us a quick note on that, or Oveis, or you? Yeah?
I mean, it's a similar concept. I mean, as you will all be aware, civil law is I mean, the stereotype is that it's a codified law, so it'll be defined in the civil code or the commercial code or both. It is intended to be an all-encompassing definition, but of course it cannot be, and defined in similar ways as was described earlier. We are seeing in Korea an increasing influence of common law jurisprudence on our civil law system. And so it's become almost hybrid. People do cite court cases, especially Supreme Court cases, in their arguments about issues like force majeure.
So there's some convergence, you mean?
There's a convergence, and of course, you see the same thing in at least in the U.S. There's a trend to codify common law concepts, but the concept of force majeure itself is very similar in
fairly
civil.
converged.
Yeah.
That's fascinating. The convergence due to globalization and market practices.
You couldn't. Yeah, I mean, the amount of trade between, say, Korea and the United States alone. If you had different definitions of force majeure that were, really substantially different, you would have chaos.
Yeah. Well, that's good. Oveis, you'd like to add anything on that point? That's all right. Okay, quick take on the rest. We have a good time. We have another 10-15 minutes. Alistair, after being sprinkled with water and blessing us.
I considered myself blessed.
Yeah.
Alistair Henderson, Herbert Smith.
Yeah.
Herbert Smith, Free Hills, apologies. 2 years in, I'm still struggling with the branding. I have a question, or maybe a commentary that comes out of stuff that Tony Kevin was talking about earlier, and then applying that to what you were saying. And I'm conscious that it may run over to Patricia's session later. So if it does, people can say, thank you, Alistair. It's an interesting question. Park it. Tony was talking about Westphalian respect for sovereignty and an element of condemnation of sanctions that reach into individual states, the hegemony of a single state imposing its views on others, if I can put it that way, and that was not giving justice to the complexity of Tony's presentation. Then there was, for example, South African sanctions, where states are looking at the internal affairs of another state, but I think it was commonly accepted then, and certainly through Tony Kevin's remarks, it was accepted that that was a good thing, which achieved a good thing. So it seems to me somewhere in there is a value judgment about what is a good sanction, reaching into the sovereign affairs of another country. Now, this panel has been talking about sanctions very much as part of black letter law, applicable law, substantive law. And that is obviously right, but I wonder this, and this is my question. A tribunal approaching a case affected by sanctions, beyond the applicable law, does that tribunal have to think about other aspects of sanctions without not forming part of the black letter law? Does that tribunal have to make a value judgment, bearing in mind the effect of public policy on the award, whether it is going to be set aside, and on enforcement of that award? If there are sanctions that are not part of the applicable law, does the tribunal nevertheless have to consider whether they are part of public policy, transnational public policy? Are they, for example, anti-apartheid sanctions that we endorse, even if they're not part of the applicable law, because they may be part of applicable public policy? That's a massive question, and I'm not expecting this even a panel this august to be able to give a complete answer to that, but I think it's a very interesting question which underlies quite a lot of what we've been talking about today, so I just put it out there.
So the in August chair of this session will give you an in August response, all right? Not August. I'm tempted because, Alistair, you know, in the realm, just as a speculative statement, in the realm of social science, which is what law is about, there is always, we understand, an interpretive horizon. The Anglo-American jurisprudence would approach it analytically, all right? Unpacking concepts like force majeure, frustration. But when you look at the text, you do bring to bear a certain interpretive horizon. You know, how you may distinguish a case, as Oveis has put, where the insurers may have contracted explicitly, how you may want to say you imply it enough that the language will allow an exit or not exit, maybe inform what you hinted of, this inarticulate premise and value judgments of impact on the public policy realm. I think this is a very good contribution, your comment, and I think that this will send all the doctors of jurists running with their white shirts and specs to, and then in the afternoon we ask Dr. Patricia to unpack some of these ideas, all right? I have a very obvious partner. Yeah, all right. We have a partner in the crime of unpacking these interpretive horizons in Dr. Yaroslav, all right? Thank you for putting the question. I don't mean to be facetious. I just thought I'd respond to that. You know, in any text, it's not that neutral because the interpretive body will bring to bear a horizon of how they want to approach it. But there are analytical rigors, I think, in the Anglo-American tradition that you can't willy-nilly bring in extraneous thing. But you may smuggle that into a careful exegesis of the text, right? But Ben, you want to say something on that? As a professor of Seoul National University?
Like any good professor, I'll ask the question rather than answer it, because I think it'd be helpful to hear from Tony, if you don't mind, whether that's what you meant, because that seems actually like a very ends-based analysis. I mean, you know, it ended all's well that ends well, and we've had sanctions in place for what could be argued to be very good reasons, and it didn't go well, and everybody condemns it. And in the case of South Africa, they made this transition in a bloodless and peaceful way, and so we think, oh, sanctions are a great thing. Was it your sort of position that this was an example of good sanctions?
Well, Tony, good. Tony, Kevin, yeah. You are also permitted to pose questions to Tony that you have no chance to. Right?
I didn't think I'd be speaking again, and I'm very conscious over the last hour of my very, very limited knowledge of many of the concepts all you lawyers have been talking about. Reminds me I have no background in law whatsoever. But let me just say a couple of things. Reminded of a saying, the proof of the pudding is in the eating. Well, the pudding tasted very good in the South African case. It hasn't in any of the other cases. I think the important thing is universality. Let's take a very contentious example. Why aren't there major sanctions against Israel for its treatment of people in the Gaza Strip, for example? Answer, because there's no universality of views. Some very important countries do not regard that as a sufficiently important issue to bring the weight of the international collective security system to bear on it. Now, you know, people will have different views about whether that's right or wrong. I'm just making that example to show that South Africa was extremely rare, and it might not have happened, but I think we can say very, very gratefully that it did happen.
So is it the exception that proves the rule?
Well, your words.
Well, I think this goes towards what we talk about, you know, the moral legitimacy to it. I mean, how legitimate is the sanctions? And is it after the event that you can see a pragmatic outcome of it or not? These are issues that besets any discourse in this area. But I think both of you are trying to dance around that issue, and it's a very and that reminds me of a phrase you used to, I think, or someone about rule-based. I mean, much as the American talk about rule-based, but in their actions on sanctions, they seem to be a fairly strong unilateralist, right? Exerting a Leviathan-like Hobbesian power, right? You know, in a very nasty, brutish world which they conceive to be against their interests. What do you think?
We advocate democracy around the world, but don't elect Morsi, even if that was your democratic choice. So there's a lot of that, and moral legitimacy, I think, is a very, very dangerous basis upon which to commence a sanctions regime. I don't disagree, of course, that apartheid is a terrible thing in South Africa or Israel or anywhere else, but I think that my sort of hypothesis, for lack of a better word, is that could have gone very badly as well, and I'm very happy that it didn't. But not every country has a Nelson Mandela, and this was probably the exception that proved the rule, in my view.
That's true, and as my final word, I'd say that there were very many people who did predict rivers of blood in South Africa, and we're all very lucky that that did not happen.
Yes. Okay. Quick take, one more. Two more. Dr. Zain? Yes, quick. We are coming to its last 5 or 10 minutes, and then I want to have the panelists have closing remarks because it's good for them to round up. Then we can go for lunch, and the lunch that Benjamin is thinking is a free trade-off for him, but it's hard life for him to work for that lunch here.
Thank you. Just another quick comment. As I was talking with my friends and colleague Faris this morning, one of the biggest threats for the enforcement of foreign arbitral award is if it's against public policy.
Yes.
Can anyone tell me what's public policy, please? Because in different countries, it's always been a threat. And what is public policy really? It's different. I mean, I'm a Jordanian Australian citizen, and I'm very familiar with both the civil law system and the common law system. And really, we always struggle, especially in many countries, would this be against public policy? And I think, just to follow up with what Alistair said before, also it's very important to have some sort of an agreement on some international standards of what is public policies. Right, so it doesn't have to have this wide interpretation, because it's always make things very difficult for the arbitrators when they're trying to issue the awards, whether it's against or not against public policy.
Well, it's a trite common law observation by a judge, isn't it? Public policy is an unruly horse. All right, whether the horse is white, black, or gallops in a certain direction, all right? We have to ride that horse, and in some instance, just to bring it closer home, there was an attempt by a local GLC trying to forestall ICC award. They're saying it's public policy, but because of the New York Convention, the price of the GLC shares in this country started dropping so rapidly, the Prime Minister's attention was called, and he called up the GLC and said, just obey that award, all right? And pay the 600 million ringgit, because it's just too, the sanctions are there. But public policy argument is an unruly horse, but you're right. Maybe something that we can talk about under the arbitrability of this afternoon, right? Issues like that. One more closing question, and then I ask the speakers to close their discourse. I think it'll be good time to break. No more? Anyone? Pat, go ahead.
Do you have any opinion as to how trade sanctions fare under Article 79 of the CISG, which of course is quite applicable in many international trade?
Wow, this sounds like a Viva Voce examination.
That's the professor in me.
Dr. Oveis, can you tell us what that article is first, and then give the answer to your former teacher?
That's a smooth question. It seems so.
That's impediment under 79.
All right. Article 79 is impediment, isn't it? Impediment. Excuse.
Well, I think it's time for lunch. So I can't answer that question based on impediment. No. So your question is, how would sanctions fare under the doctrine of impediment, essentially under the CISG?
In Iran case, Iran is not a member of the CISG. I mean, so.
Okay, no problem with that. Yeah. But let's say you are a member. Let's say you are a member. Then what? Would you want to make a comment on that, or we meet you at lunch?
Yeah, we're all members. We're all members. Yeah, I don't know. I mean, I hesitate just to give an off-the-cuff answer to that, because I would want to read the provision and give you a good answer. Maybe during your talk, I will answer that and also ask you a very tough question.
Well, we are promised an interesting contestation. Closing remark.
I mean, teachers have always questions that you say, oh, I didn't think about that, okay? So that's the teachers, okay?
But the success of a mentor is the mentee exceed the expectations of a mentor, right? And then the agony of your anxiety of influence will be overthrown, right? Sorry, I just...
I think your restate should apply. I think the same analysis.
All right. Okay, now that... that's your homework. That's your homework. All right, don't worry, your doctorate is not in jeopardy. Oveis, closing remarks from you?
Well, I again thank KLRCAA for providing this opportunity, for sharing the experience and discussing this matter, and these 2 very beneficial days on international arbitration. And, well, I have also, concluded in my talks, and what I can say right now is putting the international sanctions on the force majeure requires that we deliberately consider the applicable law of the contract and also the way that the force majeure clause is drafted, and we should put them all together to decide.
Mm-hmm. Benjamin, lunch beckons, I know, but...
Yeah, never stand between people and their lunch, right? So I'm sitting. I also want to thank the KLRCA for putting on this event. It's been great. I arrived this morning at 2 a.m., and so I'm a bit, as you can tell, about half coherent right now, but really enjoying this and enjoying the discussion from the floor. It's, I think it's very, very interesting. And Alistair's question about public policy and your question about public policy, I think is a very interesting question, which we should chat over lunch, but I won't detain you further. Thank you very much for your attention. I really enjoyed it. Thank you.
Well, when I'm asked to moderate a session like this, I say, what do I know about sanctions? But I thought that with the panel of glittering contributors, any tough question, I say, asked, my panelists, all right? I'm glad that we enjoyed the morning. I hope you did. I did. And you will show it in the traditional Malaysian way, all right? Thank you.